microphones and cameras off and use the chat function to ask your questions, which can be accessed at the bottom of your screen. So the recording is going to be posted to the Delaware Libraries YouTube channel, so you can rewatch it later and catch up on anything you may have missed. Today's presenter is Shauna Hagan. So thank you for coming out today to talk to us about divorce, even if it's not the most exciting topic. But I'm going to let you get started.
Sure. So hi, everyone. It's kind of funny being on Zoom. I know all of you were there, but you're kind of hiding from me. So I am used to doing this in a small group setting. I'm just not on Zoom. So we'll just have a little fun with this. If you guys have questions along the way, feel free to put them in the chat. I don't know that you guys can tell, but it's a pretty small group. So we should be able to take care of some stuff. So today was a really long day. So I'm just going to see what I can figure out how to start with this one. So for those of you who are considering divorce, the first thing to sort of know from a Delaware standpoint is you do have to be a resident of the state or have been here for at least 6 months. So that's kind of rule number one. So if you're new to the state, that's definitely something you'll have to wait for, because without what we call jurisdiction, you can't even file. So that's the first thing to sort of give everyone a heads up on. If you've moved here recently, you do have to establish being here from that time frame. So it's kind of the first thing that we really truly ask when someone's coming in and asking questions about divorce, is just making sure that we have the legal authority to actually, in fact, divorce you. So it's kind of step one of any kind of case that I look at. The second step is looking at if your spouse lives here, which is not an actual requirement. So that's a big, I think, misconception that your spouse has to live here. We get cases all the time. I just filed one today where husband's in Texas. He's never been in Delaware, but wife has been here long enough, so she's able to get divorced from that perspective. So those are kind of the introductory things that I think I hear the most questions about sort of off the bat when it comes to divorce. The other precursor I'm going to tell all of you is that one of the things that I think is also great and harmful at the same time is that there is a wealth of information on the internet. A lot of it is inaccurate. Delaware law is very specific. Every state law is very specific. Delaware is different than Maryland, Pennsylvania, New Jersey. So if you've heard your friends talk, well, this is what happens, that's not how it works in every state. And that's one of the biggest misconceptions that I get too, is that, well, my friend did this or that happened, or I read this on the internet. Don't believe everything you read on the internet, because unfortunately, I find most of the time people come in to see me with misconceptions because of what they've read or what they've heard. So that's kind of the biggest issue too, is that you need to make sure you're looking at the state specific information and not just the generic information on the internet, sort of as your first place to start, because I think that's where in the modern day, everyone starts and says, oh, I'll just Google this, which is great because there's a lot of really good resources, but those resources are not always accurate. The Delaware Family Court, which is where you would file a divorce petition in Delaware, has their own website through the court system that will give you the information and the forms and the whatnot. So you would actually have the Delaware specific information. So that's extremely helpful, as opposed to sort of generic things from other states that don't make sense to us. Because a lot of times I do have people come in and say, oh, well, I did this, and I don't actually know what that is. And sometimes I think they're looking at me like, well, you're the lawyer, you should know. And unfortunately, I don't, because I don't actually have any idea what you're talking about when you're using language from another state or a document from somewhere that came off the internet that is just made up. So that's sort of, I think, the biggest misnomer for anyone who's approaching this process, is to really make sure that you're using the right forms, the right documents, the right place, the right sort of everything. Delaware, from my understanding, I think this is from the Newcastle County Library, but if there's anyone who's sort of outside of our little bubble, Delaware Family Court has 3 courthouses, one in Wilmington for Newcastle County, one in Dover for Kent County, and one in Georgetown for Sussex. So you file, that's the other factors, you have to file based on where you live. So if you live in Newcastle County, you file here, Kent County, you file there, Sussex, you file there. There's no difference in the 3 counties in that sense. Delaware is in some ways unique to the extent that we're what we call a unified court system. So even though it's 3 counties and you have the county on the top of your petition, the court functions as one body. It just is where it's sort of the building that you go to is. That's very unique to us. Pennsylvania is county specific and has local rules and all kinds of different things. That's just an example. New Jersey, I think, is the same way. So Delaware, all of our forms are the same. Doesn't matter which county you file it in. The form that you pulled from this county goes to the next one. So that's a really helpful thing too, is that for some reason, if you are somewhere else, it's actually not a problem. Our forms are all state specific, as opposed to just what we call local rules in some places. So it's kind of sort of the high level big stuff that people, I think, sometimes don't think about at the beginning. The other, I'm trying to think of some of the misnomers I hear to kind of get them out of the way. For a lot of people that sort of come in to see me, I do get a lot of misinformation. And one of the biggest ones that I get is that in Delaware, we do require a 6-month separation prior to the filing or the granting of the divorce. You do not have to be separated 6 months prior to filing. You could file on day 1 of separation. You just will not be divorced until the 6-month mark is hit, from that perspective. So that's a big one that I hear a lot, is that, but I haven't been separated long enough, I can't file. Well, you can file, it just sort of sits there a little bit. It'll still go out for service, which means the other person still gets it and it moves forward a little bit, but we just can't issue that decree until that exact 6-month mark is met and some other things are met. But that's sort of the big high level piece of that one. Because that's one of the big misconceptions I hear too, is I just haven't been separated. And you can also be separated in the same house. That's another big one I hear. And that's very, very common, especially right now, obviously, given the circumstances. You just technically are not supposed to be in the same bedroom. There is a minor exception that if you are working on the relationship and you may have gone back and forth, that's fine. If your intent is to remain separated once you filed. So those are some of the big, I think, misconceptions, is that, oh, we're still in the same house. That's actually fine for a divorce petition. And I have cases where someone has been in the same house, they are divorced, and we're still dealing with property division a year later. So that's not a big issue, and it happens, quite frankly, all the time. So that's sort of a big one. The other one too, from a Delaware perspective, that's different from other states, is Delaware divorces are what they call bifurcated, which is a really big word to say. You get your divorce decree first, and then I deal with things like property division later. And I'll get into that a little bit more. But if you're just doing what we call a simple divorce without asking the court to do anything, you would get your divorce decree, quite frankly, and that's pretty much it. If you need the court to help you divide your property, and that doesn't just mean property, by the way, that means debts, retirement accounts, that's another big misnomer, alimony, things like that, that happens after we divorce you. So there's a big period of time in Delaware where, especially if you're filing right at the time you separate, that 6-month mark, where not a lot happens unless the two of you are agreeing to it happening. It's at least not happening through the court system. It's happening between the two parties trying to resolve their issues together, because the court can't really process forward anything until that divorce decree is issued. That's kind of our big line in the sand, is that when that 6-month mark is hit, the divorce decree is issued, then all the other stuff happens. So I'll talk about sort of just the petition for divorce in the sense of what you need to do. So in order to get divorced, the first thing you would do is file a petition with the court saying, I wish to be divorced. The family court has that petition online. It's available in Word format so that you can actually download it, type it, fill it out. There are a lot of pieces of paper that go with it. So that's the other thing, is just make sure you always have everything they're asking for. Because with the petition, you'll need a copy of your marriage certificate, either the original, which is a change to the statute. It used to only be a certified copy. You can now use an original, which means my client's trip to Jamaica to get a certified copy a few years ago is no longer necessary. And that actually did in fact happen. We could not get a copy, so someone had to fly there for it. So you do need that. That's one piece of paper that you actually in fact need. And if any of you were married somewhere where the marriage license is not in English or does not have an English translation next to it, I have one from Japan that has the English next to it on the formal document. It does need to be translated. The court has to have proof that you were married before they can divorce you. So that's a big factor. That sometimes does take a while to get it translated, but there are a lot of services available now on the internet that I didn't find existed when I first started practicing that actually make this process a little easier. You can find an actual translation service and you send it off and they'll send it back, and they'll, what they do, certify it's like a little seal. So it proves it's real. So that's a big, that's kind of causes a hiccup in some cases, but it's not a huge factor. You'll also have to fill out a form called the vital statistics form, which just asks you a lot of questions: name, date of birth, social security number. There's a lot of information on a divorce petition. And I know some people aren't always comfortable with that, but these are requirements from what we call the statute. The law says that I have to put this information in the petition or the accompanying forms. So you do need name, date of birth, address, absent there being a protective order that says you don't have to reveal your address, the other party's social security number, date of birth, things like that. You do need all of that information. If there's certain information you can't find, there are ways to get around it by filing what we call an affidavit that says, I've tried to find this, but I can't. Like today, I had to file what we call an affidavit of unknown social security number. Husband and wife were only married a very short time. They separated right away. She moved to Delaware. He's in Texas. She can't access any of their old their 1 year of tax returns they filed together. So she has no idea what a social security number is. So she just signed off a form that said, look, I've looked for it. I've asked, don't have it. And that's pretty, I mean, that happens fairly routinely. We just don't know. The other factor is with that same sort of idea is if you don't know where your spouse is, which does happen, you can file an affidavit of unknown address that says, I don't know where this person is. And then they will file in the newspaper to provide notice to your spouse. Interestingly enough, this is kind of a kink in Delaware, and I've never really understood it. We will file the notice in the newspaper in the county in which you reside. So in Newcastle County, we file in the News Journal. Even if you know your spouse moved to California, we still file in Delaware. Haven't figured how that's going to give anybody notice, but that's our rule. It's been our rule. There is actually some legislation pending to update our service rules on that one, because I think they're starting to figure out that that's not really service. So that may change in the future, but for now, you have the opportunity, because that's another big thing I hear is, but I don't know where the person is. That's okay. It's not uncommon, as long as you fill out the affidavit that says, I don't know where they are. I've searched for them. I asked, my former mother-in-law, they won't tell me where he is, or I have his phone number, but he won't tell me where he lives to serve him. Those things happen, quite frankly, all the time. So there are ways around it, is to file, the right paperwork that says, I've tried to do this and I can't, because those are, I think, other things that I think people come to see me in with frustration is, I've tried to do this, I can't, I don't understand, he won't give it to me, or I hear a lot, he won't sign off on it. Delaware doesn't require him to sign off, or her for that matter. You simply have to file saying you want to be divorced. There's a little more that goes into that, but in the sense that someone has to give it to you is not how our sort of circumstances work. So there's nothing that the person you're filing against signs at the beginning that says they're agreeing to this. It doesn't have to work that way. And I hear that a lot is, but he won't agree. I get that, but that's not quite what the court's looking at. So if you're in that situation where someone says, I'm not going to agree, that's fine. You can still file. And I would recommend filing and moving forward with it. Realistically, from a Delaware perspective, we are a no-fault divorce state, meaning the reason why you want to get divorced is not all that relevant in certain circumstances. So from that perspective, if you want a divorce, we're going to give you one. It's our position sort of legally that we're not going to keep people in marriages that they don't want to be in. That leads to domestic violence. It leads to lots of other things that we don't want to see. So from a divorce standpoint, if you say you are what we call incompatible, that's a statutory term, you simply don't want to be married, that actually meets the definition of incompatibility. If you want out and somebody says, no, I want her to stay or him to stay, that means you're not on the same page, you're incompatible. That's actually, it sounds so basic because it actually is. And I think people get really hung up on that he's not going to give it to me or she's not going to give it to me. It's very rare to see someone contest the actual divorce filing in Delaware. Realistically, if they've gone and seen an attorney, they have probably, quite frankly, been told what I just said, is that you certainly can, but if somebody says they want a divorce, that's pretty much all that's required from the statute. It meets the definition of incompatibility, which is what most divorces are filed under. We have incompatibility, we have voluntary separation, which is just, we agree not to be together anymore. And we do have fault-based divorce in the sense of adultery. severe mental illness. We don't file under those a lot. One, because Delaware is technically a no-fault state, even if the divorce decree is granted based on a fault-based ground, say adultery, that does not change property division. It wouldn't change child support. It wouldn't change custody. So from that perspective, we oftentimes don't always use that, even if we could, simply because it also sometimes causes more problems in the sense of trying to resolve a case and being, cordial, I guess would be the right word, in the sense of not trying to throw everything out there and start off on a bad foot and trying to get something done. But if you do file under one of the fault-based grounds, if the person does not contest the fault-based ground, it does waive the 6-month separation period. From a very realistic standpoint, most of the time it takes just as long to get divorced, even if you are under a fault-based ground, just because of timing. Divorce can take a little bit of time. It's been hit or miss during COVID. There are periods of time where I've had things a little faster, and then I've had periods where it's a little slower. So timing wise, it doesn't, even though it waives that 6 months, it doesn't always mean the court can process it as quickly as we'd like. So it's not to say if you file on April 1st, you're going to be divorced by April 15th. That's probably very unlikely. So that's just something to sort of consider, is the timing of it all, in that sense, that even if it is under the fault-based grounds, it still takes time to process the petition, get the other party served, which basically means they have to have a copy of it or it needs to be published. There are ways to serve somebody voluntarily. They can actually come in and sign a form that says, I agree to accept this by you handing it to me, as opposed to someone knocking on my door. We do that, quite frankly, all the time. That's a pretty easy one. Or they can just come to the courthouse and file an answer right away saying, I've seen it, here's my response to it. Because that's what a lot of times is the holdup too in getting things processed, is always making sure the other side has notice. A divorce is not going to be granted unless there's been some form of notice, whether, like I said, publication, which is not very helpful, because all publication is a notice in the newspaper that just says the petition's been filed. Doesn't really say any more than that, but it's still technically official notice under the law, so that's notice. Or handing it to the person, or having the processor come and serve them. So those are big issues, because service is a requirement. Your petition doesn't go anywhere without service. It just sits in a file, and eventually the court will contact you and say, we're going to dismiss it if you can't serve. So from that perspective, that's one thing that I find too that people have a problem with, is just making sure that they get that requirement done from that perspective. And that information is in the petition. That's where you would put there's a form on the front of a petition called a precipe. We like to use Latin words in the law. It basically just means this is where I want him served or her served. From that perspective, it doesn't mean much more than that. So you would make sure you do that. But the court does, again, have that form and forms on how to publish, if necessary, available to anyone who needs them on the website. So that's basically how you start the divorce process, is to file a petition. And when you file it, you are including, all the paperwork from the court and that marriage certificate. For those of you who are using the original or even a certified copy, you will never see that marriage certificate again. So if that's your only copy and you think you're going to need it for some reason, we recommend going and getting a certified copy for yourself. And we use the original, or let us get a certified copy and you can keep the original. Because I've had a few times where people have called years later wanting it back, and it goes to the court and they're not going to give it back either, because it's an official part of the file. So if there's some reason you think you need that, make sure to hold on to a copy of it, or at least get a certified copy. Most states will issue a certified copy for a fee. Delaware's, it was $25. I haven't done one in a few months, so I don't know if they changed the fees in 2021, but you can just write off to the state. Sometimes it's the county, depending on where you got married. Pennsylvania does it by county. Delaware does it by Office of Vital Stats, which is statewide. So that is one thing you definitely do want to consider, is that anything you submit to the court, generally speaking, you're never going to see again, to the extent that it becomes part of your file. So in that sense, make sure you keep a copy of everything, which I often find sometimes happens for that reason, to make sure you do that. So once you've filed the petition, and right now this is an exception. I don't know how long it's going to last, so I'll be very hesitant on this. The courthouses are open. They are open for business. Family court is currently operating, last I heard, at about 50% staff capacity. there is a civil case processing where you can actually go and fill the paperwork out in the courthouse and file it there. You can also use the forms and download them, and you can electronically file. It's hard to explain. It's not true e-filing if anyone's familiar with sort of that process. It's basically emailing it to the court. They'll call you and you'll pay the fee with a credit card over the phone. That has only been done through COVID. We do not have electronic filing in family court or docketing. So everything in family court is quite literally paper. So from that perspective, it is helpful, but on the other hand, that is a COVID only thing going on. So I don't know how long that will last. So they haven't told us at this point what the status of that's going to be. So that's just something to watch out for when you see on the website filing by email is perfectly acceptable. It's just, I don't know how much longer that's going to last since it's not a true e-file system. So when you file the petition for divorce, that is the first thing you do is, fill out the forms. So if you're asking for a divorce, and this is where I think there's also some misinformation out sort of in the world. If you're filing a petition for divorce and you don't want the court to do anything with your property, your debts and whatnot, you don't have to ask for that. You just file a petition, what we call a simple divorce petition. You get your divorce decree, the two of you walk away. That leaves you without any ability to go back to court later to resolve those issues that you thought you could do on your own. And that's a huge problem that we see, is that people file divorce thinking, oh, I'll resolve this. And that doesn't happen. You have to, at the time of filing, and it's on almost the back page, basically it's check boxes that say, I want property division, I want alimony, I want court costs, counsel fees, change my name, things like that. Those are the relief. If you don't ask the court for specific relief in your petition, you're foreclosed from ever going back for that. And what sometimes happens is people don't ask for it at the initial filing. They'll come to then see an attorney who says you'll need this. We, depending on the timing, can sometimes amend and get the court to take the jurisdiction so long as the case is not fully over. But you don't want to risk that if you think that you're going to need the court. And a lot of people don't think they are. And I hear this all the time. Oh, we've got this, we'll resolve it. And they come back to see me a year later, never ask for property division. And there's nothing I can do because the court never had the authority to do anything. So you have to make sure you give the court the authority to at least have that case go from, the divorce part to what we call the property division part. That doesn't mean you actually have to have the court have the hearing. You can certainly file an agreement and that becomes a court order, but without checking the box, you'll never have that ability. And that's, I think, the biggest thing that people lose out on, is not understanding that particular point of wanting to make sure that you've reserved all of your rights. And just because you check the box doesn't mean that the court's going to grant those things. I mean, property division, yes, we have to deal with it. Doesn't mean they're going to grant alimony. Doesn't mean they're going to get court costs or counsel fees. Changing your name, yes, they grant that. That's pretty routine if that's a factor. But those sort of relief that you see on the bottom of that page from the petition for divorce, you want to make sure that you really are thinking about it, because it does say property, and eventually they actually did a couple of years ago in parentheses did say debts too, because I think that was a big problem. Is it just said property division and people assumed you needed a house to have property division, and that's not what we mean. When we say property division, I'm talking about bank accounts, I'm talking about cars, stocks, bonds, mutual funds, motor homes. I'm trying to think of the gamut of the things. Timeshares and retirement accounts. That's a big, huge factor. People don't think of the retirement account sometimes as property, but they are. And again, without the court, you will not get a portion of your spouse's retirement upon divorce. There's a lot of forms that go into that. So from that perspective, those are the things that I think when you're filing, you really need to pay attention to what you want the court to do. Because again, if you don't ask for it, you can't go back and fix that, except for in very limited circumstances. So those are sort of the big things when you're starting out the process. And divorce is a process. I mean, there's no real way to say it otherwise. Is, once the divorce decree is issued, because Delaware does it as we call bifurcated, you will have your divorce decree while we're waiting for the court to deal with the property division or the debt division, whatever it turns out to be during that time frame. So during that time frame, if you've asked for property division or alimony, the court will require a financial report to be filled out. And again, all of this is available in Word format on the court's website for download. Some of the court's forms I don't use because I have my own, but what we call the Ancillary Financial Disclosure Report, or AFDR, we use the court's version of it. I just pull it off the website every time I need one, because sometimes they update it and don't tell us, so then I have to get the new one. So I just go to the website every time. But that's a big fun form that's sort of the next step after the divorce decree is issued, is you have to provide all of your financial information. And you have 30 days after the decree is issued to file that with the court and with the opposing party. And that 30 days goes a lot faster than you think. This is another quirk of the family court, is our mail goes to Baltimore in a state batch processed mail, and then back to Wilmington and other places. So your divorce decree, and this is just sort of on average, to get a copy of it in the mail takes about 2 weeks. It's a slow, it makes its way through the courthouse from different floor to different floor, and then eventually out the front door, and then to Baltimore and back. So if you are having property division, one thing I always tell my clients is work on that financial report as soon as possible, because 30 days is not 30 days half the time, it's 2 weeks. Sometimes the judge's office will figure out that the decree was delayed, and when they issue the letter that says when it's due, we'll actually give you a further date out than the statute requires, because they figured out that, wait, this just got mailed yesterday, that's not appropriate. But sometimes that doesn't happen. So we want to make sure we do the forms as fast as possible. Obviously, if there's an issue, we can request more time. It's just something that you don't always want to do. So you have to fill out the financial report, and the other side does, which again, in a case where you don't know where the other party is or they're not cooperating, that leads to the more fun, so to speak, issues. Once you have 30 days, they have 30 days after you do. So about 60-day window after divorce, that's when that report is due. If they don't fill it out, eventually the court's going to let you ask for, I say whatever you want, but within reason, obviously. They will send you information that says the other party isn't cooperating. Please, file what we call a formal order that says what the property division should be. And I've had that happen a few times, even with people who are professionals who just somehow bury their head in the sand and can't seem to quite get there. And that order that the court issues is just as valid as any other order. Sometimes it's harder to effectuate. If you get certain assets and you need the other party to cooperate, obviously that's a problem. But again, we go back to the court later for relief on that. But so the financial report is sort of that, from my perspective, the first time I really have a true full understanding of the party's assets and liabilities. You as the client may have told me all of the information that you have, but sometimes people's spouses have information that they don't know. So that sort of gives me a much better idea of what the property division would look like based on sort of what's in that report. And we talk about property division. Delaware law has factors that we have to consider when determining who gets what. In Delaware is what they call equitable distribution, which is not necessarily 50-50. So that means equitable distribution means that we're going to look at age, employment, earning capacity, whether you're a stay-at-home parent, whether you're disabled. We're going to look at all these factors to determine what the percentage each of you should receive is. A 50-50 case is one where maybe the parties are the same age, they make the same amount of money. There's no real other factors. That could be a 50-50 case, but you could have a case where husband makes twice as much as wife, or wife makes twice as much as husband. We're going to give the spouse that does not make as much, generally, more of the property, less of the debt, to sort of outbalance that. So one thing I often hear is, well, I earned it, I keep it. That's actually the opposite. Just because you're the spouse that earned it, oftentimes you are the spouse who's actually going to give up a little bit more in the divorce to equalize out that earning capacity issue, which is one of the major factors in what we look at, is, sort of earning capacity and length of marriage and age are kind of my three big ones. Those are kind of, when I look at a case, what I call the quick and dirty version of saying, this probably isn't 50-50, maybe 55-45, 60-40. But I mean, there are more factors, but those are the three big ones, quite frankly, that kind of give you off the bat what you're looking at. So after the financial report goes to the court, you have the right to ask for the documents that back up that information. We call that discovery. Sounds just like what it is. I file something that's called a request for production to the other party that says, I want all of this information. I want those bank statements. I want that retirement account statement. I want this. they have to provide that. There are very limited things in that context where they can contest providing it. And realistically, there's not many times I've ever seen the court issue an order protecting information that is relevant for purposes of property division. So if you ask for a bank statement, they say, oh, I'm not going to give it to you. The court's going to order them to give it to you. And if they don't, or you find that they don't disclose something, or you get the bank statements and you see an account that you've never seen before and it's not on the financial report, there is a recourse, because that does happen. People, are not always 100% truthful. So we do have a little bit of recourse there, and that's what the discovery process is for. There are cases where the parties have come to, someone has come to see me, there's another attorney, and we've been able to verify enough independently that we're not doing what we call substantial discovery and saying, I want every piece of paper that ever existed, but I do want these couple of things just to check numbers. And then we, oftentimes resolve a case that way. But if there is a dispute, if someone says, no, that's not my account, or, I don't have that doesn't exist yet, you're looking at the documents, you have every right to ask for those documents. You can also issue subpoenas to the third party, the banks and things like that. Our discovery rules have just changed a little bit starting at the beginning of the year. We have a little more leeway on that than we had before. Sometimes we used to have permission to do certain things, and now it's a little broader. I haven't seen too much of it in action just yet, just because I think we're still all used to the old ways of just asking for it from the person. But yeah, you can go to the bank, or if you know where it is, and try to get that information in order to try to figure out exactly what exists, what doesn't exist from that sense. And once the financial report is filed with the court, after that 60 days, the court will hold a teleconference in some cases. If it's to what we call unrepresented parties, which the legal term is pro se. Sometimes the court doesn't always hold the teleconference and just issues the scheduling dates because they don't have to consult an attorney calendar. If there's one attorney, generally speaking, even if there's a pro se on the other side, they will have a scheduling teleconference so that we know that we can check our calendars, and they will put a date for what they call a pretrial and a trial on the calendar. Again, doesn't mean those things are actually going to happen, but if we don't put them out there, that's kind of my way of saying, I've got a trial next week. Okay, this is the case I need to work on this week. It's just the fun of lawyers or procrastinators. We're not going to pretend we're not. I need something on a calendar to tell me what I'm doing and what my deadlines are. So the court's going to issue those deadlines, and everyone has to follow them, both parties. And again, if one party doesn't, you've got relief with the court to go back and say, look, they've blown this deadline. They did this, they did that. That's where a lot of times the court cost and the counsel fees come in. Because Delaware is a pay your own way state, where we follow the American rule, which is basically you pay your own fees. The times that I see fees being paid for the other party is if someone's not cooperating with discovery or not cooperating. The general divorce case, we don't often see fees being paid. We do follow that rule. That's pretty much you pay yours, I pay mine. So that's not something that I think that's a big issue, is when someone comes to see me with the petition for divorce that has that box checked, I'm not paying. Realistically, the chance that you pay somebody else's fees is pretty slim. The other factors, if there's a huge income differential, substantial, that one party, you have a stay-at-home parent and you have the CEO of a corporation, yes, you might get fees that way. But in the general normal day-to-day where, people are working, regular jobs, so to speak, we don't often see fees get paid in that sense. We ask for it every single time. I check the box without question. I've gotten it pretty rarely, only generally in cases where someone's not cooperating. So I think that's a big one too, is that I get is from that perspective. And one thing that I just thought of with that one is, if you're not the person filing the petition, say you've gotten served with a petition or been handed one, and those boxes are checked on the back, property division, when you file an answer, you don't contest those particular items. They just exist. I had someone come see me and said, but I don't want to pay that. Yes, that's true. I understand you don't want to pay it, but in your answer, there's actually no way to say, I don't want to pay that. The answer is more of, yes, this is my name. This is my date of birth. This is when we separated. And this is, where I live, kind of thing. So I get that a lot, but I don't want to do this. So how do I answer that? Those certain things you can't actually answer. You just kind of have to go with the flow on those and make your arguments sort of at the time that you need to. Because I've gotten that question a few times, is how do I not do that? And you can't really answer in that respect. So, most of the stuff happens after the divorce, unless you have people who are willing to negotiate beforehand. I can't make you. I can't make you fill out the financial report any earlier. that kind of thing. And that does happen as I get one person who's raring to go, ready to get this over with, and the other person's not. There's very little I can do during that time frame unless they're voluntarily giving me information and working with me. Once the divorce decree is issued and those deadlines start, then I'm actually able to enforce sort of the rules and use the court if necessary. But you have to, one thing that I think gets missed a lot is that you might be the one who's ready for the divorce, and your spouse, well, they're not contesting getting divorced. They, on the other hand, are not quite ready to sort of admit it and go through the process. So that does sometimes happen, and if they're not in the good headspace for that, that actually doesn't make help anything, pushing it forward too much, simply because from that perspective, you're sort of dragging someone along, and maybe you could resolve it a little better if you just gave it some time. So from start to finish, if you've already hit the 6 months at the time sort of your filing, you're probably looking at 6 months to 9 months ish on property division. COVID has not really affected property division that much. In some of our stuff's a little slower. It is hit or miss. Sometimes we do have slowdowns just randomly, and it is a little harder to get documents. People working remotely, it takes a little longer for the banks to get back to us and things like that. But generally speaking, we're still in a pretty decent time frame compared to a lot of states, from what I understand. So from that perspective, at least in this world, we're not doing too badly. If you haven't met the 6 month mark, then obviously you are looking at hitting the 6 months, and then, another 6 to 9 months sort of after that. That's, one thing. You could be looking at a year and a half, just depending on where you are sort of in that separation process from that perspective. Trying to think. So if you resolve the case, which realistically most of our cases do resolve, and we just file what we call a stipulation with the court that says husband gets this, wife gets this is how we're doing it. That happens fairly often, that we are able to agree. If you can't agree, you will have a trial with a judge where the evidence has to be presented. And I think that's another big misnomer. When I say trial, I really do mean a trial. It's like you see on TV to the extent, but there's no jury. You're talking to the judge, and you do need evidence. You do need to say, if you say, well, he's got a bank account, and you don't have anything that proves that, or some inclination that proves that, you can't meet your burden of proof. You have to be able to prove it. And the rules of evidence apply. I know people think family court's the Wild West, and sometimes we are, but the same rules of evidence that apply in another courtroom apply. There are certain things that can't be testified to without the person who created the documents. What we have something called hearsay, which gets muddled all the time, but things like that. You do have to be prepared that you do have to follow the same rules of evidence if you're doing this on your own as an attorney would. Yes, there's some leeway, but not completely. From that standpoint, is you want to make sure that everything's, you have the documents that you need and that are required. Or if someone didn't give you the documents, that's a different argument. Is then obviously the court's going to take into consideration what we call a negative inference, that there's a reason we know this document exists, and someone's not providing it because it must say something negative or has a value on there that, so from that perspective, that's a little different, but you do need to be prepared to present your case. What will happen is if you're close to trial and it's not resolved, you will have to go to a pre-trial, which is where the court asks you to fill out a form it's a pre-trial stipulation. It looks a lot like the financial report, but it's a little nuanced, and it's where you kind of boil down to, I agree that this is this number, that's that. It's, what you agree on and what you don't, and the court will go through that with you. And then, if there still is no agreement on everything, basically the court will take it to trial. And we have cases that get tried for different reasons. One is we might agree on all of the values of things. Like we know that the house is valued, at some number, and the car has this value, but we can't agree on what the percentage to each person is. Then we try the case on that limited basis of what the percentage is. There are some cases where we can't agree on values. We have an appraiser that says one thing, you have a second appraiser that says another, and no one will compromise. Then the court has to make the call on what sort of the property is worth. And that's another factor, something that I think people do. Some judges are a little more lenient on accepting sort of the Zillow reports and the Trulia and the Redfin and whatnot. Others say, without an appraisal, I can't value your house. It's going to have to get sold. So that's something to watch out for. And sort of with that, I get this question a lot too, is that, but I want to keep the house, and that's fine. One thing that I think is a misconception is that if the mortgage is not in your name or is jointly, you have to get the other person off the mortgage. The court can't do that for you. That's a bank issue. I think that's a big misnomer. But the court said I could keep the house. Yes, the court did, but they probably told you you needed to refinance it to remove the person's name from the obligation. If the bank won't give you the loan, that house is ending up getting sold, or the other party's going to buy you out. And that's realistically what happens. Is another one I get, that people come to see me after the case is over and saying, but the court said I could have it. It's not that simple, unfortunately. There are things that the court can't control. They can say they can keep something, but they can't require Wells Fargo to give you a mortgage, and they can't require your car company to change the title of the car. They don't have the legal authority to do that. They can tell you to do something, but they can't tell a company to allow you to do things. So unfortunately, I think that gets missed a lot, is needing to understand that there are outside factors. Just because someone agrees that you can do something doesn't mean that the bank will or the lender will. So that's another sort of factor that I kind of see a lot that's out there. Trying to think of things that I see sort of that are out there. So like I said, once the court makes a decision, you have an enforceable order. If the person doesn't want to cooperate, you can file what's called a rule to show cause, saying so-and-so is not cooperating, help me out. And the court oftentimes will. I've had the court sign deeds for me when somebody won't. I've had them sign what we call qualified domestic relations orders to divide pensions and retirement accounts when the other party won't. That's the other thing to sort of watch out for. That is also, I don't think a lot of people pay attention to as much. If you're getting a portion of your spouse's retirement, or they're getting a portion of yours, that's generally done by a rollover using complicated legal documents called a qualified domestic relations order, otherwise known as a quadro. So a lot of people don't know to do that if you haven't consulted an attorney, and the order says spouse A is getting $25,000 from, the Fidelity 401k. Well, it's not as simple as someone removing $25,000 from Fidelity and giving it to you. There's documents that go to Fidelity to ensure that it's a rollover and there are no tax consequences. So I think that gets missed sometimes too, is that people don't think to do those documents. They don't realize they have to. And I've had people come back 5-10 years later and say, this never got done. And we need to do it. And sometimes we can't clean it up because the account doesn't exist. The money's gone. I mean, you're still entitled to it, but it's hard to get once it's gone. So those are things that I always think people need to pay attention to and try to sort of maybe do as soon as possible, is get those documents done. And if you're representing yourself, I would highly recommend having an attorney at least review before you file it. They're very complicated. Even ours get what I call bounced back all the time. Every company has a different format. So we'll call the company and ask for it. And someone's like, oh no, we don't have a format. Go ahead and send one in. Then they send it back with 25 changes. It would have just been easier to tell me what you wanted the first time. But so these are very complex issues that drive us nuts. So when you're trying to do it on your own, I can imagine it would probably drive anybody nuts from that perspective. Is there are a lot of nuances in some of this stuff that's just a pain, quite frankly. There's no other way to say that. I think they do it on purpose to drive, people insane. But a lot of the companies actually do have their documents available. Fidelity, I will say, is one of the best. Most of their stuff is actually online, so you can pull it and follow their format. So those are just kind of little things that are out there. One of the other things from an alimony standpoint that I hear a lot is, but we haven't been married 20 years. That's not a requirement. The 20-year mark just means that if alimony is granted, it's what we call lifetime. And that doesn't always mean lifetime. Obviously, people are allowed to retire and things like that, and you have to take that in consideration. But generally speaking, lifetime means it goes on forever. If you're married under 20 years, the max is 1/2 the life of the marriage. So if it's 10 years, 5 years is the maximum. So that's how we look at it. And Delaware is what we call a dependency state. You don't just get alimony because your spouse makes more money. You get alimony because even though you're working, or you have the inability to work, disability or something like that, you can't support yourself. We don't just give alimony because there's an income differential. We give it because someone is required, and we look at the standard of living and things like that. So those are all, that's another big misnomer I get to. Same thing with pensions, but we weren't married long enough. There's actually no time frame on getting part of your spouse's pension. The court can order it a year in if they feel like it. I mean, you're not going to get a lot, generally speaking, but they can order it, certainly. So those are kind of the big ones I hear a lot when someone comes to see me, that, like I said, the misnomers of the internet. I've sort of been looking at the bottom of the chat feature. No one's asked any questions. I'm just trying to look at time. Does anyone have any questions? Maybe? Anyone? I lost them all.
No, just a clarification. So for what you're saying, or what I understood was that people don't get alimony just because they want to get it, right? It had to be a need for it.
Yes.
Okay, I work with a lot of clients, and divorce is a grand topic, and they always say it's like, "Oh, I'm gonna ask for alimony." I'm like, I think that doesn't work like that. That's what I'm describing. So I'm glad I hear that.
And that's actually one of the biggest ones I get all the time. But he owes me or she owes me.
Uh-huh.
Not how, yeah. This is, and like I said, when I was talking about fault, people say, well, he had an affair, I'm going to get everything. No, you're not actually. It has no bearing whatsoever on my property division nor my alimony. From minimal in the sense of it doesn't change the factors. All of a sudden, you don't just get everything because somebody did something wrong. It's kind of in the very generic sense. Obviously, every case is fact specific, but in the overarching sense is what I hear all the time is, but I need to file under this ground or I won't get this. And that's not how that works. That's why that is one of the reasons we're no fault. Like we want to look at the property division and the alimony through the lens of the actual financials and things like that. And one other thing that sort of just made me think about that is what is different in Delaware and other states, if anyone's coming from somewhere else, is when you're getting divorced and dealing with property division, alimony, things like that, that is one sort of process. Child support, custody, those are separate processes in Delaware. They're not tied to the divorce. So if you're getting divorced and you have children, just because you're getting divorced is not going to automatically mean there's going to be an order for custody. You have to file separately for that. Same thing for child support. You have to file separately for child support. Some states will do it as a lump, basically, like their orders will be divorce with property, child support, custody. Delaware, everything is an independent. Actually, in this case, they're called petition numbers. So everything, you have a case, you have a file, and then each individual sort of item under that child support, each has its own number. So they're not the same thing. And just because you get divorced does not mean you have to file custody and child support, or just because you file custody and child support and you're still married for some reason doesn't mean you have to get divorced. Like none of that sort of mixes in together. We do have to consider child support and alimony because it's money coming from sort of the same hands back and forth, but that doesn't, they're not the same proceeding. Sometimes they get what we call consolidated, but they're independent of each other to the extent that you can file one without the other. So that's something that I also see that's a little, I wouldn't say unique to Delaware, but it is, we're very clear that this goes to this goes to that, and that goes to, sort of all of those things. Any other questions?
Thank you.
Shauna, did you want to put your contact information in the chat in case anybody wants to reach out to you afterwards?
Sure. See if I can remember my phone number today or type at the end of the day. There you go. So I gave you guys my name and my office line. The one thing I would tell anyone, realistically, if you're getting divorced and there are issues of property, even if you don't think there are, you would be surprised that there are issues pop up all the time. I would, even if you can't afford to retain an attorney, I do understand it is very expensive. It can be to get divorced. I have cases that range from a few $1,000s to I have a $50,000 divorce right now. I mean, that's just, it is, unfortunately, there's a huge gamut to that. I would suggest just at least paying for the consultation. Have that consultation with someone before you do anything. Or if you and your spouse agree and you have what we call a separation agreement or some sort of agreement that you've drafted yourselves, make sure you have an attorney look at that. That agreement is a contract. It cannot be modified, generally speaking. I mean, if it's horrific, I've had a few that we've had to modify because they're so bad, but that costs so much more money on the back end to try to modify it and fix something that on the front end would have been much cheaper for me to have just drafted. So I know people are hesitant sometimes to spend that money. It is worth it just to have that. Most people, it's an hour, some it's a half an hour, just depending on the lawyer. And there is a question that popped up, which the petition for divorce currently, and this is off the top of my head, is $175. The ancillary items that go with it are $100. And the parenting class, you don't have to take before you file. you take that while the case is basically pending. But you are required, if there are children, I completely forgot this one, that if there are minor children, and that is under 17, they finally clarified that. The way the rule read for a while, 17-year-olds, no one knew whether if you had a 17-year-old, you had to take the class or not, because it could be read both ways. I think we've now figured out if they're 16, but not yet 17, you have to take the class. You take the parenting class, it's a requirement. Only you have to take it, your spouse does not. And that has changed over the years so that you're not being held up by somebody else refusing to do it. The children no longer have to take it. And as of COVID, it is now available online from an online provider that we didn't used to approve. And most of the providers are doing it via Zoom from that perspective. Yeah, and you don't need the filing, the parenting class before filing for custody either. You file that with the court after the petition has been filed. And from the custody standpoint, it used to hold up scheduling. It no longer does if it takes a while to take it. So that is a new change in the last 2 years or so. Anyone? And the court's filing fees are all available on the website as well. I'm just going off the top of my head, and I should know since I just cut a check to the court today for a divorce petition. But each case is slightly different because if I ask for alimony, but I don't ask for property division, the fees you pay for each individual thing. The divorce is one thing, property division is another, alimony is another. Court cost, counsel fees. There's no and to change your name, there's no fee for that. That's just literally a box you check. And then if you have a separation agreement that you want to file with the divorce, that's the same fee as if you were going to ask for property division. So from that perspective, there are some fees. Oh, and something that I thought of today too, because someone asked me this, is in Delaware, it doesn't matter who files first. We are not what they call the race to the courthouse state. Just because you file first doesn't mean anything other than your name is first and you've paid the fees. If your spouse wants to file and you, for some reason, deem it necessary to file first, that's fine. It won't change anything other than your financial report is due before theirs. But yeah, it's not a race to the courthouse like in some states. It's just, we don't really look at who files first. So, and by the way, you no longer have to go to court to get divorced. We've been doing it on paper for years. You just fill out a form once the 6 month is met and say, I'd like to get divorced, sign here. And that's pretty much what happens. There's a few times we go to court when someone doesn't agree, but that's pretty rare these days. I've only had 3 of those in 17 years.
So I guess while we wait for any last minute questions anybody has, I'd just like to remind people that we have some sessions coming up that may be of interest to you based on what we talked about today. Shauna is going to do a talk on custody on May 20th. There's also protection from abuse on May 13th and child support on May 27th.
All things I do all day long. Hopefully, yeah, I'm glad you guys got somebody else to come give some topics they'll get bored of me.
So there's another question in chat. Is there a fee waiver for the initial processing fee for divorce for low-income families?
There is. What I will tell you is it is hit or miss, and it's very, there is no line that says if you make this, you pay this. It's case specific. So the one thing I will tell you, if you do need to file what they call the fee waiver, it's in the Latin words in forma pauperis. That's actually what it says on top. But if you ask for a fee waiver, they know what you're talking about. The more specific you are in answering the questions, the better you'll have in the ability to waive the fees. It asks specific questions about your income, your dependents, how many children you have, what your rent, mortgage, car payment is. I also, unfortunately, I don't file those as private counsel. I wouldn't get them granted. In a few pro bono cases I have, they've been filed before I've taken the case on without the fee. So I don't file them all that often. So I'm going off the top of my head, but from my understanding, the more specific you are and the more information you do give, they can give a better assessment. Because I have seen ones that just say, I can't afford it and doesn't have any information. And those are just outright denied. But if you file one, and I do know that if you're on Social Security, they'll look at, if you attach the security statement or if you unemployment, which is a big factor right now, obviously, that's one. They'll look at your pay stubs. They can also, one thing the court can do is they don't always waive 100% of the fees. They can say, will reduce the fee to 50 as opposed to 150. But it is completely up to whichever judicial officer gets that document to grant it. So there's absolutely no way to know whether it'll be granted or not. That's one of those ones where go ahead and file, give them all the information. And unfortunately, that's the best we can say, is that's all we can really do. There's no, like I said, standard. So that's the hard part. I don't know what that standard, what internally the court is looking at. It is case specific.
So I guess on that note, it is now 7 o'clock. So if you have any more questions, Shauna had put her office number in the chat, so you can give her a call. And yeah, thank you for coming out today. Thank you, Shauna, for talking. It was a lot of great information.
Yeah, it's
And
a lot.
as I,
Sorry.
that's okay. And as I mentioned at the beginning, the recording is going to be posted on the Delaware Libraries YouTube channel. So if you missed anything, you can always go back and watch it afterwards. So, yeah.
Thank you.
Thanks, everyone. Everyone have a good night.